Paul Wayland at Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all based on a sliding scale based on your income. So the less you make, the less we charge. Today, we just want to discuss mental health in criminal cases. So the mental health of a defendant can play an important role in a criminal defense case. There are two different aspects of mental health when it comes to mounting a defense based on the defendant's mental health. The first one is criminal responsibility, and number two is competence. So what is, and these are separate matters, separate from each other, totally different, although they both do address mental health issues. The time frame is different and also what the court looks to, and the permanency of that designation are different. So let's take a look at each one and get a better idea of what each one is all about. So the first one is criminal responsibility. Criminal responsibility means that at the time of the alleged crime, so that's the time frame. That has to be at the time of the crime itself, the alleged crime, when that took place, that the defendant was unable to appreciate the wrongfulness of his or her acts. That's number one. Or number two, he or she understood the wrongfulness of their actions, but they were not able to change their behavior because of their mental illness. Okay, so it's either they didn't know something was wrong, or they knew it was wrong, but they didn't have any ability to stop doing that wrong thing. So again, that takes place at the time of the crime. So that doesn't change. If a defendant is found to be not criminally responsible, that's it. The person is not criminally responsible. It doesn't matter if it was a temporary situation and that person has now gone on to regain a better mental health situation. It's at the time of the crime. So even if you get better, it will look back to that period of time. It doesn't change over time. So this is what you often hear referred to as an NGRI, or a not guilty by reason of insanity. It's the insanity defense. We don't use that term very often. It's kind of an old-fashioned term, but basically that's what it is, and that's what you can think of if you ever watch TV shows or movies or whatever. That's what we're talking about. Still in place. It's just called criminal responsibility more so than an insanity plea. And basically what happens is it comes down to experts. There's usually a battle of experts between the defense and the Commonwealth. So each one will hire an expert, a psychologist, a psychiatrist, or something along those lines. And that person will do an evaluation of the defendant. And again, they are looking to what was the defendant's state of mind and state of mental health at the time that the crime was committed. These cases are very hard to win from the defense's point of view, because juries don't really want to accept that somebody's mental health could affect their behavior so much that they are, what in their mind might think, are allowed to commit crimes. So they are very difficult to win, and the expert is absolutely critical in making your pitch to the jury that this person was not responsible due to their mental illness. If somebody is found to be not criminally responsible, and especially, let's say if it's some sort of really serious crime, that person doesn't necessarily get away scot-free with and is able to walk the streets. Typically what happens is the Commonwealth, that is the prosecution, will ask the court to hold this person at a hospital, at a mental hospital, a locked facility. So they wouldn't go to jail necessarily, but they would be asking, and typically this is what happens, is that they are sent to a mental health facility where they are under lock and key and can't get out and so forth. So with this, and they come up for reviews every so often if they are sent there, whether they are basically safe to be released to go out into the community. If you speak with mental health experts in the field and in criminal law, they will tell you that this can be a very slippery slope. What I mean by that is, if once you go down the mental health, criminal responsibility, mental health route, the person is subjected to being locked up, still being held away from his or her loved ones and so forth, but it's not in a prison and it's not for a set period of time. So they don't get sentenced to jail for a year, let's say. So they go into the mental health facility, to the locked facility, but there's no specific end date for them. So in a way, this can work against the person in the fact that they could be held for an indefinite period of time with no particular release date. So someone who ends up in this situation may well end up under lock and key for a longer period of time than if they just took their case to trial or pled out to the charges and were given a sentence of committed time. Because at least if you get a sentence in a jail or in a state prison, you know what your release date is. So that's one thing to keep in mind. Now, let's take a look at competency for a moment. So competency is different from criminal responsibility. Competency is the person's current state of mind, current mental health situation. So what that means is that the person. So what the court looks to is they're looking to see if the person is able to consult with their attorney, and if the person is able to understand the proceedings. So everybody in a criminal setting has to be able to consult with their attorneys, to give feedback, and to participate in their own defense through the help of their criminal attorney. And if the person's state of mind is such that they are unable to communicate with their attorney in a substantive fashion, then they can't participate, and they are not competent to stand trial. The other thing is that they must understand the proceedings themselves. So they will be asked, and they need to know, who is a criminal attorney? What does your criminal attorney do for you? Do you know what the charges are against you? Do you know what happens to you if you get convicted of this crime? Who is the prosecutor? What is the prosecutor's job? Who is the judge? What's the judge's job, and so forth? So they have to have an understanding of what the process is itself. So they have to be able to communicate with their attorney, and they have to understand the overall process as well. Experts, again, play a major role in making the pitch for competency or non-competency from our point of view, and it's up to the expert for a great deal of the time in convincing a judge that the person is not competent to stand trial. And what happens is, if we believe that our client is not competent, we would have them evaluated by an expert, and then there would be a hearing between ourselves and the prosecution. The prosecution would also hire an expert and have them interview the defendant, and it goes before a judge, and ultimately the judge makes a ruling, yes or no, the person is competent to stand trial. Now, if the person is not competent at the time, that status can change over time. So it could be through the use of medications. It could be through the use of some other treatment or therapy, something along those lines. So a person can be returned to competency over time. So the case will stay open and will be reviewed every so often to see if, in fact, that person has been returned to competency. If they are now competent to stand trial, the case will go forward as in the normal course, and will push forward just as if the competency issue was never involved. If the person is never returned to competency, the case will stay open for a period of time, and that period of time is 1/2 of the maximum committed time that's allowed under the statute for the particular crime that you are charged with. So, for example, if you're being charged with a crime where 10 years is the maximum amount of jail time that you would face, after 5 years, if you have not been returned to competency, the case would get dismissed. The case can also get dismissed shorter than that period of time at the discretion of the judge, in the interest of justice. That's the term that's used. So if for some reason your attorney is able to convince the judge that, hey, look, judge, he or she hasn't been returned to competency, probably looks like they're not going to be, and there are some other situations, some other consequences that are going on that require you to take a look at it, and in the interest of justice, we're asking that the case get dismissed at this time. So that's basically the mental health defenses that are available to a criminal defendant in Massachusetts. So again, at Afford Law, we'd be happy to answer any questions you might have about any family law or criminal law questions, competency, criminal responsibility among them. Please feel free to visit us at affordlaw.org. Please feel free to book a free, confidential virtual appointment. We'd be happy to answer any questions that you might have. Our rates, again, are drastically reduced from what most people charge. We use a sliding scale based on your income. So the less you make, the less you have to pay, because we believe that people, hardworking people who are confronted with a family law or criminal law situation should have the ability to be represented by experienced, competent, compassionate legal representation. So again, please visit us at affordlaw.org. We answer some of your questions at the website. I'd be happy to answer any specific questions that you have. Please feel free to book a virtual appointment with us. At Afford Law, we're making justice affordable.